Trademark and copyright all seem so familiar, right? But do you really know the differences among those? Don't worry, we are here to help you identify them. In this video, we will talk about the definitions, the main differences, and the most important question, how not to infringe and misunderstand these two forms of intellectual property. In case all those theories would sound boring to you, not a problem, because we'll bring you a case between Kawhi Leonard versus Nike. Regarding the definitions, trademark and copyright are both subject matters of intellectual property, which can be defined as intangible assets. In other words, creations of the mind, such as inventions, designs, symbols, names, and images used in commerce. The main difference, therefore, between copyright and trademark is that although both offer intellectual property protection, they protect different types of assets and have different registration requirements. To better understand the difference, let's break down the details of each of these protections individually. What does a copyright protect? A copyright is a form of intellectual property protection that covers original works and is generated automatically by the creation of those works, including poetry, novels, other forms of original writing, art, research, movies, songs, other forms of audio and video materials, computer software, and architecture. In short, as long as the original work is preserved in some form, it is protected under copyright when it's created. On the other hand, however, works that are not available in some tangible form, such as a speech that wasn't written down or recorded, cannot be copyrighted. Other work that cannot be copyrighted include ideas, discoveries, principles, listing of ingredients or contents, works that are considered common property, such as calendars or height and weight charts. So, how to protect a copyright? As we mentioned briefly above, in addition to what copyright and trademarks protect, another difference between the two is how these two are protected. Here are some examples. Properly marking. You can make sure your work is properly marked, such as signed or with a watermark, and that there's a clear evolutionary footprint from the work to your business. Number 2, poor man's copyright. This is the practice of sending your own work to yourself, thereby establishing that the material has been in one's possession for a particular period of time. However, there is no provision in copyright law for any such type of protection, and poor man's copyright is not a substitute for registration. Number 3, Creative Commons. Creative Commons offer free right licenses that allow you to mark your creative work with the freedoms you want it to carry. And lastly, use the copyright symbol. At a minimum, you can use this symbol to denote a copyrighted work. On the other hand, let's discuss what a trademark protects. A trademark is a subject matter of intellectual property rights that covers words, phrases, symbols, or designs that distinguish a particular brand in comparison to others. In short, a trademark can apply to anything that essentially brands a business or identifies a product or company. Here are some well-known examples: the Tabasco bottle with the hexagonal screw top, Foot Long by Subway sandwiches, or the McDonald's golden arch symbol. Therefore, a trademark protects items such as brand names, logos, business names, and slogans. So, how can we protect a trademark? First, you want to do a trademark search to ensure that your branding materials are not already in use. Additionally, you might decide to work with a trademark lawyer to assist in trademark registration. For registration, trademark owners have two options: either directly register a trademark in Vietnam by filing an application for registration with the Vietnam NOIP, or seek the protection in Vietnam through Madras system. For the first option, the trademark owners need to prepare, file for registration, and pay a fee as the requirement of Vietnam intellectual property law. In case a trademark needs to be protected in a number of nations, including Vietnam, the trademark owner may register the trademark through Madras system. As a reminder, the differences can be summarized as copyright protects original work, whereas a trademark protects items that distinguish or identify a particular business from another. And also, copyright is generated automatically upon the creation of original work, whereas a trademark is established through the common use of a mark in the course of business. Now, let's move on to this case study. We'll bring you the case between Kawhi Leonard versus Nike. So, United States District Court located in Oregon upheld a copyright registration held by Nike Incorporated for a design of the claw logo depicting Leonard's initial KL and his jersey number 2 within an open hand. Leonard had been claiming that he was the owner of the design, as he had originally drawn a rough sketch of it back in 2011, and that Nike had created a derivative work of his original drawing when he was under an endorsement deal. The court ruled that contrary to Leonard's position, the claw was not, but rather was an independent piece of intellectual property that Nike had full rights to. As you know, copyright protects creative and original expression. It covers all types of creative works, from music to film to books to art. Trademark law, on the other hand, protects brands. It covers devices like words, phrases, or logos that providers of goods and services use to identify their goods and services and differentiate them from those of other providers. While these are typically very distinct areas and cover vastly different rights, one area that they overlap is logos. A logo can be both a copyright and a trademark, as it can be both a form of creative expression and used to identify a brand. However, as mentioned above, each covers different rights. Copyright in a logo would prevent others from reproducing, distributing, making derivative works, or displaying the logo without the owner's permission. A trademark, on the other hand, would prevent other businesses from using a logo that is either the same or would likely cause confusion to identify and promote their own similar goods or services. As a note, one can gain what is referred to as common law rights in trademark, once used in commerce, or copyright, once fixed in a tangible medium, without formally registering with governmental entities, but they are not as strong as registered rights, which are always recommended to be obtained when possible. So, how does all this relate to Leonard versus Nike's situation? Here's how. When Leonard first drew his original logo, back around 2011, he potentially gained common law copyright in that drawing. During the deal, Nike made changes to that drawing and started selling it on shoes, potentially granting Nike a common law trademark in its new logo. When Nike filed for copyright with the United States Copyright Office, it gained rights in registered copyright. After the deal ended, Leonard, without knowing Nike filed the copyright, filed for and received a registered trademark from the United States Patent and Trademark Office for the new logo for use on various clothing items, but not including shoes. At this point, when Leonard sued Nike for copyright infringement, he was claiming that his common law copyright should trump Nike's rights in its registered copyright as a derivative work. However, as stated before, a federal court has held that Nike's logos is not a derivative work of Leonard's, but rather its own independent creation. Additionally, once Leonard sued Nike for copyright infringement, Nike sought to have Leonard's registered trademark cancelled. However, on March the 13th, 2020, the Trademark Trials and Appeals Board overturned a cancellation of Leonard's registered trademark, restoring it in full force and effect. Is the new logo really an independent creation or not a derivative work? Decide for yourself. So, do you have any questions? If yes, please comment below and we will try our best to answer those questions. And also, don't forget to subscribe and like our videos. Thanks for your listening and see you soon in the next videos.